Senator Whitehouse.
Thank you, Chairman. Before I ask questions of the witnesses, I wanted to bring up something that has transpired since Ms. Rao's hearing that, to me, calls into question how truthful she was with the committee. I know that virtually every standard and norm and practice of this committee has been broken through in the mad rush to confirm all these nominees, but I do want to at least remark on what I think is a very significant lack of candor on two subjects. Both Ranking Member Feinstein and I asked questions for the record, the written questions that come after the hearing, regarding the funding of an organization called the Center for the Study of the Administrative State that Ms. Rao ran. We asked specifically about the Koch Foundation and the Federalist Society and anonymous donors. And to Senator Feinstein, Ms. Rao responded, "To the best of my knowledge, the center did not receive any money from the Koch Foundation or from the Federalist Society," end quote. And to me, she responded, "To my knowledge, the Center for the Study of the Administrative State was not founded with money from the Koch Foundation. Moreover, the center did not receive money from an anonymous donor." Okay, we take that as her statement. But then we find through documents that were released through FOIA, the Freedom of Information Act, that the Center for the Study of the Administrative State, in fact, did receive financial support from both the Charles Koch Foundation and from an anonymous donor. In fact, in 2016, George Mason University received a $10 million donation from the Charles Koch Foundation and a $20 million donation from an anonymous donor, both earmarked with support for her Center for the Study of the Administrative State as a condition of the gift. The New York Times has verified this, reporting, quote, "a $20 million gift from an anonymous donor plus $10 million from Mr. Koch's foundation. According to university documents, the agreement called for bolstering Ms. Rao's center." Separately, it's a minor matter, but the dean of the law school made it clear that the Center for the Study of Administrative State received $300,000 in funding from an anonymous donor. So I know people don't want to talk about all of this, but this business of big special interests funding the Federalist Society, which picks the nominee, funding the Judicial Crisis Network, which campaigns for the nominee, funding these amicus entities that come before the courts, and now not being told what appears to be apparently not being told the truth about this, to me it's a real matter of concern. If we can't expect people who answer our questions for the record to tell us the truth, that's a very important hole in the process that we all participate in here. The second had to do with her contact with the Federalist Society about faculty candidates at this Center for the Study of the Administrative State. She was asked, did she have any contact with the Federalist Society when she was considering potential faculty candidates? She responded, no. And then she went on to say that the law school's hiring committee occasionally, and I'll quote her here, received recommendations from the faculty division of the Federalist Society. What she failed to disclose was that she was a member of the faculty division of the Federalist Society during this period. She was basically talking to herself on this subject. I don't know how that is not pertinent and disclosable information in response to that question. To me, it signals that nominees in this administration aren't taking this committee process very seriously because it is a treadmill. It's on automatic pilot, and everybody gets to go through, particularly at the circuit court level and particularly at the DC circuit. So I just want to make a record of that because I'm very concerned about what is happening to this committee, and to me, this demands further clarification and explanation. My question is to Mr. Collins, and it is this.
That will not count against your time. You can.
Thank you. Posit a fossil fuel industry party with a case before you and explain to me how the adversary of that fossil fuel industry party could conceive that they will get a fair hearing from you, and specifically what your recusal standard will be when fossil fuel industry corporations come before you and fossil fuel industry arguments are made to you.
I identified, Senator, in my response to the questionnaire that cases that involved former clients of mine would be an area that would require an inquiry.
That's pretty
whether
obvious.
or not it was a case in which I should recuse under the applicable standards. And I would consult those standards in light of the particular case and make the appropriate judgment. And if that is to recuse in that case, I would do so.
Would it matter to you that a party or an attorney came before you with a feeling that they were dead on arrival in front of you because of your history representing the fossil fuel industry and that you couldn't give them a fair shot?
I would hope that they would not have, if I reached the judgment that I wasn't required to recuse, I would hope that they would not have that. I know that the standard looks at what a reasonable person who knows the circumstances would conclude, whether there was an appearance of impartiality or a loss of impartiality in the circumstance. And I agree that the appearance of impartiality is often as important as the substance of it.
Let me read you something you wrote on behalf of ExxonMobil in the Kivalina case. You wrote, "Climate change allegedly results from the aggregate effects of greenhouse gas emissions from billions of sources around the world accumulating in the global atmosphere over the course of centuries, and thus it cannot be attributed to the defendant energy companies." So let me go through some pieces of that. Why did you say allegedly?
The reason why is purely the procedural posture. It was on a Rule 12 motion. It is a verbal tick of lawyers in Rule 12 motions always to say allegedly, because you're always taking the facts as alleged as true. And so that's what we were doing in that circumstance.
Okay, so let's look at the facts. Do you actually believe that climate change, as we are trying to reckon with it, results from the aggregate effects of billions of sources around the world accumulating in the global atmosphere over the course of centuries? Or is it more accurate, factually, to say that the climate change we're trying to reckon with comes from carbon emissions caused by the burning of fossil fuels that has taken place essentially entirely in the last century?
I continue right now today to be counsel in cases that involve alleged tort claims that are asserted arising from climate change. And so I don't think it would be appropriate for me to express a personal view on the underlying facts in a matter in which—
Well, you did. Here's what you said. I'm just asking you to defend it because it looks to me like it's false. And if you're willing to say something as false as the concern about climate change is something that relates to aggregate effects of greenhouse gas emissions from billions of sources over the course of centuries, when that is very distinctly not the problem, when it is very distinctly attributable to emissions from fossil fuel combustion, I think I'm entitled to challenge that to you and ask you to defend it. If you're unwilling to defend it, that tells me a lot.
The question, what you're referring to with the statement in the brief, and is the aggregate contribution of all carbon dioxide. And then the question in the litigation is the share of the contribution from the energy industry and how much that contributes to it. But it's not false to say that all of the carbon dioxide contributes to the problem. The issue was the amount of the contribution and whether there should be tort liability.
I think it is false to attribute what we discuss as climate change, using that word in its normal parlance, to things that happened hundreds or thousands of years ago, when we all know perfectly well that it has happened since the Industrial Revolution. And I know because of who your client was, that was the thing to say, but I think it is actually factually false and misleading to say that, because had those prior conditions continued absent the change of all this added carbon dioxide from fossil fuel, we wouldn't be having a conversation about climate change. That's why I think it's misleading. My time is up. That's why I think it's going to be hard for people coming before you as a judge to believe that if a fossil fuel company is on the other side, they'll have a shot with you, and I think that's not appropriate for people approaching United States courtrooms.
Yeah, would you want to say anything?
The only thing I would add is that I'm not sure the other side in the case disputed that all of the greenhouse gases that are emitted into the atmosphere and that remain there now from all of the sources intermix and contribute to the global phenomenon of global warming. So that statement that you read, Senator, that's all that said, and I don't think that's false. I don't think anyone really disputed it. The heart of the litigation was the amount of contribution of greenhouse gases from the energy industry and whether that should give rise to tort liability. And it was a legal issue about the availability of tort remedies for that.